topic for the webinar is how to enforce court judgments. So we'll be giving an overview on the most the most common methods to enforce and execute your court judgments. And at the end of it, there will be a question and answer session, so you can raise any questions at the end of the talk. So I'll hand it over to Nicholas to start first, and I'll take over after that.
Right, hi everyone. So first we'll look at what we call a writ of seizure and sale. So what this is essentially is it allows you to essentially take the property of the judgment debtor, you know, their physical property, to be sold, and the proceeds of that sale goes to paying the debt that the debtor owes to you. Right. So usually, of course, as you can tell, this is in case of a what we call a money judgment, right? A judgment where you have someone who is to pay you money by order of the court. In other words, all of this is happening after you've already gone through the process of filing your suit against them in court. You've gotten judgment, whether it be after trial or by way of summary judgment or some other summary process, right? So this also applies to movable and immovable property. In other words, it applies to landed property, it applies to your movable belongings, even your laptops and your furniture and so on. Now, the thing to note for this, and actually for enforcement in general, is that you have 12 years, right? From when the judgment became enforceable, you have 12 years to execute on the judgment. And areas on interest, in other words, any interest is outstanding, that one you can only recover up to 6 years. So while it's a long period of time, as you will find out, it is best not to wait, right, for both practical and legal purposes. Now, for writ of seizure and sale, how do you get one? The first thing you have to ask yourself is, do you need leave of court or do you not need leave of court? Right? If you don't need leave, you can apply, and as a matter of right, you will get it. Right? So it's fairly straightforward. If you do need leave, then you'll have to file an application and essentially justify yourself. Now let's look at the situations in which you need leave. These are all listed out in the relevant order there, right? Order 46 Rule 2.1, and essentially they are like this, where there's been 6 or more years that have passed since you obtained judgment, and this is why we say you should not be waiting around to try and execute, right? If you've got a judgment against someone, don't leave it till too long to do it, because if it's after 6 years, now you're going to have to ask for leave, and you'll see if you look at the body of case law, leave is not something that they will give you just because you ask for it, right? You're going to have to justify yourself why you didn't do it earlier and so on. Now, there may, of course, be real circumstances in which that you have a good reason for waiting 6 years, right? Perhaps you had some sort of payment plan with them to pay over a long period of time. Perhaps it's a very large judgment sum, and you've allowed them to pay off per some arrangement that you have. But after 6 years, they started to stop paying or avoid your calls or evade you essentially. So then that's when you may want to take more drastic measures like this. So that could be one thing. Another situation in which you need leave is if there's any change in the parties. So of course, common one is one of the parties die, right? If your judgment debtor dies, then you will need leave because you will then essentially be starting proceedings against their estate, in effect against whoever is the administrator or executor of the estate. If the judgment creditor dies, then it's the reverse, right? It is whoever is managing that person's estate having to seek leave to bring execution against a debtor of a dead person. Alternatively, where it is already sought against the assets of a deceased person, but the person only, in essence, the assets only comes into the hands of the executors or administrators after judgment happened, then that's also where you need leave, right? So similar to a change in party situation. The other scenario that you'll need leave for is when the relief you get, so it could be money, right? But it's subject to a certain condition or something else that you have to fulfill. So this could be anything, and it really depends on what the claim was you brought against them and what the judgment says. So to take an example, it might be something like the judgment orders the person to transfer a certain other asset to you, right? Not in the form of money, but in failure of which, then only if it's not possible anymore, if it's no longer doable, then in lieu of that, they pay you a certain amount of money. So that may be one case where there's a condition that has to be fulfilled first before you can ask for execution to get proceeds from sale of the person's belongings. right? So that's where you have to satisfy the court that this has happened. So obviously this one is perhaps not so difficult to get leave for, provided you've got everything in order and everything is done already. Okay. The last situation is where the property is not in the person's hands technically, it's in, say, a court-appointed receiver. That's when you need leave as well. Now, the discretion of the court when it comes to this is something that you do have to take note, because like I said earlier, if you wait too long, especially the 6-year thing, you have to explain why, right? Because the law essentially doesn't like it when you sit on your rights and wait. Just because you have a right to bring a claim after a certain number of years does not mean that the court is going to like it that you waited till the last minute. And actually this applies to the filing of normal suits and claims as well, if you're aware of limitation of what you call, let's say, acquiescence and laches, right? If you are delayed in bringing a claim in such a way that makes someone think that you've abandoned your claim, right? Or maybe even you've said something to the effect of like, oh yeah, I don't really want to bring the claim anymore. Then even though you're within the limitation period, it may be that the court says, actually, you've abandoned your claim. So similarly here, it's not exactly the same, but similarly, the court here has to look at why you have a delay, what the cause was, whether it's something that's reasonable and that satisfies them. All right. So even though you're within a 12-year period, there's a reason why they've got that 6-year period in between there where you need leave versus don't need leave. So really, wherever possible, you should bear this in mind when you are going for this, right? So say you've got an agreement with someone on paying off the judgment debt, you may want to see if you can have that all settled within the 6-year period, so that if there's a failure on their part, you still have this open for you and you don't then need to go and take the extra step of obtaining leave from court. Now, if the situation doesn't apply, right, you don't need leave, just apply for issuance of a writ of seizure and sale as of right. Right? And these are all the technicalities. There's a certain form you've got to follow and rules of court. Your lawyer will be able to advise you of that and help you draft that. And once it's issued, it's valid for 12 months. You want it to be valid longer, you've got to extend it. Right? And again, if you're asking the court to extend it, you're asking them to exercise their discretion. There will be certain things you have to satisfy the court of. Now, what happens when you get your writ of seizure and sale? At that point, it's the sheriff or bailiff who will essentially be doing the legwork for you, so to speak, right? They will go to the person's address, their premises. They'll try to get in, and of course, within all reasonable boundaries, they will try to do it in a pleasant way, let's say, right? They'll try and give the person, get permission from the person. They'll let them know what they're there to do, right? This is not some gangster thing where they go and they break down your door, unless absolutely necessary, right? But the key point is they have this power. So you cannot shut yourself in there and refuse to entertain them. They are there as officers of the court. They are empowered by the court. So there's only so much you can do to fight it at this point, right? If you are on the receiving end, if you are the judgment debtor. So do take note of that. And when the property is seized, when movable property is seized, be sure to note that a notice of seizure must also be given. In other words, despite the fact that you're having this sort of draconian situation where someone's belongings are being taken, it must still be accounted for. There is a due process to this. They must be given requisite notice, right? Now, there are exceptions. It's not a case of the bailiff comes in and everything and anything in the house is fair game, right? The law has to carve out certain exceptions. And if you look at this list, you'll see that what it's meant to reflect essentially are essential items, right? So your clothing, your everyday utensils, stuff you need to live day to day, essentially, right? Any tools you need in your work. So if, let's say, the laptop is a main part of maybe you're a graphic designer and you must use your laptop in the course of your work, then you might argue that this is something that they cannot seize, right? Your clothes, they cannot seize. Books of account, they cannot seize. So all this is to say that, number one, this is not meant to suddenly kick you out on the street and then you cannot live anymore. Neither is it to embarrass you to the point where the bailiff comes in and out and then you're left with absolutely nothing in your house, no clothes to wear, nothing, right? That's not what the point of this is. It is only to take, within certain reason, properties of yours that can be liquidated into money to use to pay off your judgment debt. Yeah, this is the continuing list. So wages and salary, so on and so forth, right? So so that's why, and we'll get to this later as well. If you are the judgment creditor and you're looking to reclaim to be paid some of your monies. It would help if you had an idea of what property the person has, right? Because if you have a judgment debt against some impoverished person, they've got no assets, no real belongings, no money. You can spend your money to execute this way, but you may not get a lot of return for it. And it may not be worth it to you, not worth your time, and frankly, you'll just be causing these people headache. Nobody wins, so to speak. So once seizure has been made, this is a technical point. Any dealings by the JD with the property seized will be void. In other words, it's no longer technically the judgment debtor's property anymore, right? If they turn around and try and sell it, that sale will not be valid. And the bailiff here is empowered to then sell all these properties by way of public auction, where the money that's raised from the sale will go to you, the judgment creditor. Now, when it comes to immovable property, right, your houses and so on, it is a slightly different route, right? You need what we call a prohibitory order, which first prevents the JD from essentially getting rid of the property, right? Because what you don't want, of course, is judgment is entered against this person, then they very sneakily try and get rid of the property before you can come and take it. And then by the time you get to them and ask for your money, or they've got no assets left, and there may be nothing you can do. Right? So you apply for a prohibitory order, you serve it on the judgment debtor, you register it essentially at the land office. So at that point, it's deemed to be seized. Now you can see the reason why you need a different mode for movable versus immovable, right? For movable property, it's very easy. The bailiff goes there, he takes it, he asks someone to literally carry it out, and that's how you restrict physical access. But immovable property, there's nothing to take, right? You have to essentially change ownership on paper. And essentially that's what this is, right? It takes it away, takes it out of the hands of the judgment debtor and make sure that they cannot deal with it. And then you can move forward from there, right? So this order is valid for 6 months unless renewed, all right? And the discretion, again, discretionary power by court to renew should be exercised with caution, because in this case, right, it's not just a normal renewal of anything. You are taking away a person's ability to deal with very significant property, likely to be of high value, and you also don't know what the property may be used for, right? What are they deriving some sort of income or something else from it? So it's a question of balancing competing interests. Now, after you've prohibited the dealings on the land, what do? You get a sale of land, right? It can only be made after 14 days after you register the prohibitory order. So the condition of sale and all that, those are the formalities that will be drawn up by bailiff or by your lawyers as well. The judge will approve this. This is all something your lawyer will have to advise you on, right? And can this be set aside if it's sold? Yes, but if you look at the rule in question, it is not, it's a very particular thing you have to prove, right? First is material irregularity or fraud in publishing or conducting it. This could be, for example, where you got your prohibitory order, but you did it illegally. You know, perhaps you didn't give notice as you were meant to. Perhaps you made a fraudulent representation in the course of obtaining your judgment or something of that nature. The other way is if the JD has no saleable interest in the property sold. Now, practically speaking, when should you go for a writ of seizure and sale, right? First, of course, is where you have a money judgment. You have a judgment for someone to pay you money. Second, it would be good if you know that the JD owns this property of a certain amount of value, that it's worth spending money on your end to go for, to have it sold, and that it will be worth your time, right? And thirdly, that the property is available, it's at their address, it's not hidden somewhere, and so on. And that the property you're having your eye on is not does not fall under one of the exceptions. Okay. And lastly, that the JD is not the government, because government has special protections in general when it comes to court and lawsuits. Now on to my colleague Sue, who will talk about Garnishee proceedings.
Thanks, Nick. So I'll talk about Garnishee proceedings, which is another method in which you can enforce a monetary judgment. So garnishment order is where a third party, in most scenarios it would be a bank, to pay some or all of the debt owing by the judgment debtor to the judgment creditor. So the total amount payable by the Garnishee, the third party, is limited to, of course, only the judgment amount that is owing by the judgment debtor to the creditor, and also the costs of the legal proceedings involved. So to understand how Garnishee proceedings would work, it's really to think of it as a tripartite scenario. So first of all, of course, you have your judgment creditor. This is the person to which a debt is owed. So the judgment creditor would usually have obtained an order for the payment of money against the judgment debtor. The judgment debtor is the person who has to pay whatever amount that is owed. So they need to satisfy the judgment debt. Now the third party here is the Garnishee. So this is the third party who has a debt due or accruing due to the judgment debtor. So actually the phrase debt due or accruing due is important because what can be garnished is what's called an actionable debt between the judgment creditor and the judgment debtor. So actionable debt means the debt must actually be owing. So it's not something that's prospective in nature. So the most common scenario is where you actually already have a court judgment which says that judgment debtor must pay judgment creditor 100,000. So that's actionable. Contingency debt would only come into play if the contingency actually happens. So that is how Garnishee proceedings would work. So we'll explain the mechanics further. The relevant provision is Order 49, Rule 1 of the Rules of Court. So where a person who has obtained a judgment is essentially for the payment of money by some other person, the judgment debtor, not being a judgment or order for the payment of money into court and any other person within the jurisdiction, is indebted to the judgment debtor. The court can subject to the order and of any written law order the Garnishee, the third party. So the third party will be the one paying the judgment creditor the amount of any debt that is due or accruing due to the judgment debtor from the Garnishee. So it's a lot of words there, but essentially judgment debtor owes something to the judgment creditor. But the effect of the Garnishee is that usually the bank will then pay the amount to the judgment creditor because there is an amount between the Garnishee and the judgment debtor. So with that relationship, the Garnishee will pay the debt owed to the judgment creditor. So I think we can go to the next slide. Yeah. So this slide is to show the importance of demonstrating the existence of a judgment debt. So this High Court decision of Kedah Klang Papan Sendirian Berhad and Hanso Sendirian Berhad, it establishes some of the key principles that need to be taken into account where a judgment debt is concerned. So as briefly mentioned before, no Garnishee order may be made unless some person at the time the order was made was indebted to the judgment debtor. So again, there needs to be an actionable debt. Now, if there is no debt in present, but there was a debt in existence, i.e. a debt that may not be payable now, but is payable in the future, then that is still actionable. So an order could still be made with regard to that debt. But what is important to bear in mind is that it's not enough to show that there probably will be a debt, but it has to be shown that there was in fact a debt. And those are sort of the key principles which govern when you can have a Garnishee proceedings. In terms of the procedure, it's a two-stage process. So normally when I talk about Garnishee proceedings, I like to explain it as a sort of a freezing of a bank account. The reason being that at the first stage, what will happen is that if we're talking about banks being the Garnishee, the judgment creditor will obtain an order that will attach or freeze the judgment debtor's bank account. So this is the order nisi. That's the stage where first, the amount that is in the bank account is frozen. It could be more or it could be less than the judgment sum, but that will be frozen. Nothing happens yet, it's just that it can't move. But at the second stage, the court will then make an order for the bank, the Garnishee, to remit the monies in the judgment debtor's account to the judgment creditor. So then the money will then go to the judgment creditor in order to satisfy the judgment. So this is known as the order absolute. So in summary, in Garnishee, it's always a two-step process. First you freeze and then you pay. So that's broadly how it would work. So if you are the judgment creditor and you want to take the monies from the judgment debtor's bank account, so how do you do it? You make an ex parte application supported by affidavit. So ex parte means you don't need to give notice to the other side. So your affidavit will explain what is the judgment or order to be enforced. Usually you would already have a court judgment, and you will state the amount that is unpaid at the time of the application. Maybe the full sum hasn't been paid by the debtor, maybe part of it hasn't been paid. So as the creditor, you will state to the best of your information or belief of the deponent, the Garnishee, whatever bank it might be, is within the jurisdiction and is indebted to the judgment debtor, and stating the sources of the deponent's information or the grounds for his belief. So this is found in the Rules of Court, Order 49, Rule 2. So usually you will move for Garnishee proceedings if you know of the judgment debtor's bank account. Somehow you manage to find out the bank name and the bank account details, and you have reason to believe that, yeah, there's probably money there that can pay off your court judgment. So that's when you might want to consider filing this ex parte application to explain, basically to identify the sum that you're seeking. So you make the application to the court, and the court will decide whether to grant what is called a show cause order or not. It's under Order 49, Rule 1, Subsection 2. So after you get the show cause order, what happens is that you serve it at least 7 days before the court hearing. So you will serve it on the Garnishee, so usually the bank personally, and unless the court orders otherwise, you also serve the show cause order on the judgment debtor. So the effect of this show cause order is that it shall bind in the hands of the Garnishee, as from the service of the order on him, any debt specified in the order, or so much thereof as may be so specified. So whatever amount that is stated in the order itself. So then what usually happens is that the bank, having notice of this show cause order, they will usually inform the debtor that this amount has been frozen pursuant to this show cause order. So usually at this point, the judgment debtor will also have notice. So if the Garnishee does not attend upon getting the show cause order, there's a hearing date. So if he doesn't attend or does not dispute the debt due or claim to be due from him to the judgment debtor, the court may then make an absolute order against the Garnishee. So this is Order 49, Rule 4. So when an order absolute is made, then the money will be paid by the Garnishee to the judgment creditor. And in the next slide, we will see that if the Garnishee is disputing liability on grounds which we'll explain later, to pay the debt due or claim to be due from him to the judgment debtor, the court can either summarily determine the question at issue or order that any question necessary for determining the Garnishee's liability to be tried in any manner in which any question or issue may be tried. So in short, if the Garnishee is raising any grounds, the court can decide it from the outset, maybe just based on oral arguments that are submitted, or the court may order for it to be tried in the normal process. So what might be the basis for Garnishee to dispute liability, i.e. the Garnishee says, no, this sum cannot be paid out to the creditor. So maybe the Garnishee is saying that they cease to owe the judgment debtor any debt. Maybe there's no money in the account. judgment debtor's account with the Garnishee bank is held on trust for a third party, so a third party is actually involved. Or the judgment debtor's bank account is actually jointly held with another person. So what we can see here is that the judgment debtor's bank account needs to be essentially free from encumbrances. You can't bring other people, other account holders into the situation, because you are, I mean, it's quite a unilateral thing to do, to freeze the money in the account and then order a payout to the creditor. So there are these sort of safeguards in place where the Garnishee can dispute liability. But there is the caveat is that, as found in Order 49 Rule 8, is that however, if the Garnishee does act pursuant to an order absolute, this is a valid discharge of its liability to the judgment debtor to the extent of the amount paid. So what this means is that even if later on, for whatever reason, the Garnishee proceedings are set aside, or the judgment or order from which they arose are reversed, doesn't matter, because the Garnishee would have already essentially done his job by following the order absolute. So there is no sort of remedy against the Garnishee for properly following the court order. The order absolute, even if later on it turns out that, hey, actually Garnishee shouldn't have been instituted. So that is what the rule is getting at. So broadly speaking, Garnishee proceedings predominantly involve the judgment creditor and the Garnishee. So I think that's quite evident from the previous rules we saw, where you need to serve the show cause order on the Garnishee, but it's possible for the court to say that it's not necessary to serve it on the judgment debtor. However, if a judgment debtor does seek to set aside the Garnishee show cause order and order absolute, there is recourse to that. So it's possible to file an application to do that. And a third party who is entitled to the monies held by the Garnishee can also apply to challenge the Garnishee proceedings. So these are certain, again, mechanisms in place to stop any abuse of process. But broadly speaking, it really is between the judgment creditor and the Garnishee. So if there is a proper court judgment that orders payment from debtor to creditor, usually there wouldn't be any issue with getting an order absolute to get a payout. So you would institute Garnishee proceedings if you have information that a third party is owing the judgment debtor a certain amount of monies, for example, a bank, and you know that that particular sum is due to be paid at a certain time. And if the judgment creditor has good grounds to believe that the information that he or she has obtained is reliable and correct, then it may be to the creditor's advantage to start Garnishee proceedings. But just a word of caution is that be careful not to tip off the judgment debtor prior to the filing of Garnishee proceedings, because what will naturally happen is the judgment debtor catches wind of it. The money, any amount of money that is left in the bank account, he will of course withdraw it, so that there is no attachable debt. So there is essentially nothing to freeze. So that is for Garnishee proceedings, it's perhaps best done when you have the information, you move fast, and you also move like pretty in a stealthy manner. So that's the overview of how Garnishee proceedings would work. And for this next one, judgment debtor summons, Nicholas is going to give an introduction on this, and then we'll follow it with Q&A.
Thanks, Uwe. So for a judgment debtor summons, it is pretty much what the name implies, right? You are summoning the judgment debtor to court, and you are examining them in court. In other words, you're asking them questions about their assets, their liabilities, the property they have, and so on. The overview is that you do this when you want to get a better idea of what the judgment debtor's financial situation is, what assets they may have that they might use to be able to pay off their debt, and it can be a good starting point for you to then decide what ways you want to go to execute against them further. So where you have a money judgment, again, we're focusing mainly on money judgments, right? And it's to pay whether by installments or by lump sum, however it is. You can the judgment creditor can then summon the judgment debtor, right? Or if the JD is a company, there are also ways to do that, right? There's a slightly different procedure that can come into place when that's the case. But the gist of it is you can summon either the individual whom you have a judgment against, or an officer of the company against whom you have the judgment, to be orally examined. In other words, they sit there in court, sort of like trial, right? They sit there in court, you ask them questions and they are bound to answer truthfully, right? The only key thing is that the examination pertains to their ability to pay or satisfy the judgment debt. So of course, you can't drag them there and ask them anything and everything about themselves. All questions have to ultimately relate to this question, right? What property they have, what debts they have owing to them, or what other debts they have owing to other people, and essentially how they can so arrange their affairs to pay you. And the other thing to note is that where you're called on this way, you may have to produce documents, books, other things to substantiate what you're talking about, or what you may be asked in respect of what property or assets you have. So that's actually quite a broad remit that this empowers judgment creditors with. If you notice, you can cover quite a lot of ground here. And that's why people say that in some sense, right, this is not strictly speaking execution, it is technically discovery, at least at the first stage. You're trying to discover what their situation is financially. And this enables both you to decide how you want to proceed against them next time, and also the court in determining whether they should make an order for them to pay the money and what arrangement would be best for them, right? Because think of it this way, sometimes you get a judgment that you get a judgment against someone, it's for payment of a lump sum money. Oftentimes the court is not going to at that moment say, okay, this one to be paid by so and so installments, right? If what they owe you is a simple lump sum. But at the JDS stage, at the end of examination, that is something the court can consider according to the person's ability to pay, the justice of the case, and so on. Now, the procedure is, well, I won't bore you with the details. Your lawyers will handle this for you, but you file a certain form, all right? It's issued, it's sealed by the court, and then you have to serve it on the judgment letter at least 7 days before the hearing date. So similar to the Garnishee order earlier that we were referring to, right? You've got to serve a certain number of days before the date that the court has given you for hearing or for return of the matter. And at that point, they have to attend in person to be examined orally. Okay. And in relation to this, you can technically also subpoena someone else to act as a witness of the person's financial situation. So it's not just a case where you only have to take that person's word for it. You may be able to bring in someone else if you know they've got relevant knowledge and can speak to the matter. Now, what happens if the JD doesn't show up? Right, very simple. They don't show up, they may be arrested. An order of arrest may be issued by the court so that they can drag you to court forcibly, or they may even make an order against the JD ex parte, meaning without him being in attendance. So it's not something you can easily evade. If you are served with the order to show up at the hearing, then it is best that you do so. And if you don't, you also best have a reason why you're unable to attend. So this is essentially what happens at the end of the process, right? The court officer hearing it, oftentimes I hear it's a registrar, will then decide whether, or can decide whether the JD is to pay the judgment debt, either the whole debt or part of the debt in one whole lump sum in one go, or by installments in any manner that they think is reasonable. Okay, so this is where they have to balance between what the JD is capable of doing and the consequences if they fail, right? That's why it's important for the court and you as a JC to get an accurate idea of what the person's situation is. So if you've got a judgment against someone who does not seem to have a stable job, no stable income, no significant assets that is reasonable to make them liquidate, no other, let's say, perhaps no spouse who's deriving significant income either, no other way to make money, and where you don't expect to make money soon, and maybe they also don't have other people who owe them money, right? So they can't call on other debts to pay for these debts to you. Then the court may decide, okay, look, it's not fair to ask the person to pay you such a big amount in a lump sum in a short order. So they may spread out in installments across a long period of time. And I have heard of these cases where I think in lower courts, especially, you've got a lot of litigants and judgment sums that are not extremely large by court standards, but large enough for your average person that they really can't just pay so much a month, right? Think of yourself, for example. How much cash do you have coming into you every month that you could feasibly and reasonably be forced to pay, right? You pay for your mortgage already, that's a fairly big chunk of, let's say, your monthly salary going up. Imagine then if you have to pay off a judgment debt as well, right? So here is where it's important for the court to come to a reasonable installment plan if that's what is needed. And it's also important for the JD to therefore comply and be upfront about their situation. Now, of course, every JD who is summoned is going to want to look like they don't have so much money or don't have so much capacity to pay, because none of them obviously wants to be out of pocket immediately and for a larger amount than they can help, right? But the more open you are to showing that this is your situation, then at least the more information the court has, because it's up to the court at the end of the day, right? So you do have a lot of people who go to JDS, and at the end of the day, the judgment creditor does not get the best order in their favor, so to speak, right? It's payment over a long period of time. And that's just the way it is, because there's no point to having a court system that errs so much on the judgment creditor's favor, where you suddenly have a string of people who will essentially go bankrupt or cannot live their life or cannot make enough of an income to support themselves and their family. So I think that's a common theme you will see with all these different execution procedures, which is that it is there to make sure that the JD cannot run away from their obligations to pay, but neither is it there to basically put all of these people out of business and bankrupt all these people, because that does not help anyone as well, right? To some extent, if you want to get your money back and the person you're claiming it from just has financial constraints, then it's in your best interest as well to make sure that they can continue to make money and earn money in the future so that they can pay you off, right? Because if you were not concerned with that, then you could just bankrupt them immediately, and chances are you get nothing or close to nothing, right? So failure is where the judge makes an order, the court makes an order, and then the JD defaults, right? So if it could be installments, it could be the lump sum. If they don't follow what the court orders, the JC can then apply via a notice to call upon the debtor to show cause. In other words, to explain why they've not been able to pay and why they should not be thrown in prison for defaulting on court order. Whether they're able to justify this, as you can imagine, is very, very factual, right? It really depends case by case what the reason is. If maybe there's a material change in their circumstances, perhaps they've just lost their job unexpectedly, all right? And you've got to serve this within a certain number of days as well, that's stated there, Order 74, Rule 13. And if no sufficient cause is shown, in other words, if you, the JD, cannot explain well enough, then the court can make an order to commit you, right, to put you in prison for up to 6 weeks or until payment is made. And the thing to note is that committing you to prison does not discharge your debt. So it's not a question of, oh, okay, I'll just forget about complying. I don't mind going to prison for however many weeks it is, and after that I'm free. It doesn't work that way, right? It's meant to essentially to pressure you to comply, because there must be a stick, not just a carrot, for you to comply. Otherwise, the order of the court will just be a paper order, means nothing, right? So now we get to where there's a lack of financial means on the part of the judgment debtor. So again, this goes down to the question of the court's discretion, right? If they think that the person, the judgment debtor, is unable to pay some and not to be discharged, then they can order a discharge following this, right? So again, it comes down to you being able to justify yourself to prove all of this. It's not just a question of you plead with the court and they take your word for it, right? So as with everything else, having documentary evidence, having records, having other people maybe who can speak for you, all of that would be helpful. Okay. So that's essentially all. Now we'll take any questions you might have. I think I've already been told of a few, which I'll take first. We've got one question saying, with regards to writ of sale and seizure and sale, what if the JD does not have any knowledge of, I assume you mean JC, like what if the JC does not have any knowledge of the JD's property details? What is your advice? Well, so where you don't know what their situation is like, actually then you may want to consider JDS, right? If you're able to serve on them the order to attend court to be examined, and you don't really know what property they may have, then bring them to court and ask them and make them answer in court what they have. So from that examination, then you might have a better idea. Oh, okay, they've got so and so immovable property here and there. They've got this and this income. Then you can decide. Maybe you go for a prohibitory order against a house that you have. Maybe you go and garnish certain bank accounts. All of that is information that you might dig up during a JDS that could be helpful to you. We've got a question on Garnishee proceedings. Perhaps Suhei you can take. The question is, how do you proceed if the JD does not have any knowledge over which bank is the debtor's bank? And two, what if the JD also has no knowledge on, I assume they mean JC, what if the JC has no knowledge on whether the debtor has how much money, in other words, how much money is in the bank account? If the amount of money in the bank account is insufficient to pay off the debt, do we name 2 or more banks in the Garnishee order? And lastly, do you apply for this Garnishee only after you receive an order, or can you even do it during SOC stage?
Yeah, thanks, Nick. So just to answer the first question, how do you proceed if the judgment creditor doesn't have any knowledge over which bank is the debtor's bank? So I think as what Nick mentioned, then you will probably need to look at other means through which you can enforce your court judgment, because as far as Garnishee is concerned, you do need to have some knowledge of the bank account and the name of the bank. So it is rather limited in that sense. So if you don't have the information, you will usually have to resort to other means to do it, to get the judgment sum. And I think that ties in with the second question as well. What if the judgment creditor also had no knowledge how much money the debtor has in the bank account? Again, it's a bit of I guess it's a stroke of luck in a sense, because you never really know how much money there is in the account. Unless you somehow have some inside info on it. But otherwise, I mean, in a sense, it usually doesn't really matter how much you know, or rather, doesn't matter whether you know or not how much it is in the bank account. Usually, if you have reason to believe that the bank account is an active account where money is usually coming in, then that might be worth a shot. So to give an example, I think previously, we came across a situation where the judgment debtor actually owed, I think, a few $100,000. So in the end, the amount that was garnished turned out there was only 11,000 in the account. So too bad. I mean, they just had to take what they get. And then in terms of the remaining amount, that is again up to the judgment creditor how to proceed in terms of the remaining amount. But you never really know that information. And the third question is that if such amount of money is in one bank is insufficient to pay off the debt, do we name 2 or more banks in the Garnishee order? So it is possible. I have come across instances where I think 2 or more banks were named because they were not sure which was sort of the more active account. But I think in the end, it turned out that in fact, both didn't actually have a lot of money in it. So again, that was just something they had to try, but then what the judgment creditor did was also to go for a writ of seizure and sale, either at the same time or after. So it sort of boosts your chances of getting it if you pair up the methods in which you try to enforce the court judgment. And the last question is whether you only apply for the Garnishee order when do you apply for the Garnishee order? Do you do it during the SOC stage? So the thing about Garnishee is that, as mentioned before, you do need to have an actionable debt. So it does tend to happen upon getting a court judgment. That is really the norm. It is not something that you do right from the start, because you would need to show that there's a basis for the debt to be in existence. And even if it's a contingent debt, that's not good enough unless the contingency happens. So it would be, as with WSS, as with JDS, it would be at the tail end of proceedings that it would usually be the norm. And I think there is a final question for Nick as well. I think, when can we apply for JDS? Is it at the beginning during SOC stage, or only upon obtaining the order and prior to execution of the order?
So as with Garnishee, you generally, actually no, in this case, not even generally, you do need a judgment. You need a judgment first, right? Because when you think about it, examination of someone as to their financial status, that's quite draconian as well. It would not be prudent if anyone could drag anyone there on the basis of a debt in which it's not been tried yet, right? Not tried and proven in court yet. So you do need a judgment for that. And when it comes to Garnishee as well, as Sue has mentioned, this is also usually the case. And the other reason lawyers will, I think, tell you usually to go and get judgment first is if you try your luck without a judgment, chances are the other side is just going to say it's disputed, it has to be adjudicated, there are all these complicating factors that need to be tried first, and then you just get it thrown out. So really you should get a judgment first. Now, as to whether you can apply for JDS prior to execution, it actually does run concurrently. So there is nothing to stop you from, let's say, applying for Garnishee and also doing JDS at the same time. And in fact, when it comes to execution, where you might want to move fast to lock down their assets before they can transfer it or get rid of it, this is actually something you may want to do. You don't want to give them notice, right? So if you're doing a JDS, then I think anybody who's represented by a lawyer will essentially know that you are considering coming after them, the other assets that they may have. So if you have knowledge already and you're able to apply first, right? You don't have to do JDS then something else or something else then JDS. Do what is best for you that fits your circumstances, and your lawyer will probably be able to give you good advice on this if you can tell them what you know and what you don't know about the judgment debtor. Are there any other questions? Okay, looks like that's all for now. If you have anything else, you can always try and get in touch. If you've got a case, you can get in touch with the firm and try to set up a meeting as well. We'll be happy to advise you.
Thanks, everyone.
Thanks, everyone.
Thank you.